our program. We started doing these 4 or 5 years ago, and we've experimented a little bit and done a lot of lunch and learns, and we've added some breakfast of late, and I think we're going to go with the breakfast because this looks like it's a better option for a lot of y'all. And so we appreciate you making your way from various parts of town to get here, because we know that's not always easy in Atlanta. My name is Doug Reeder, and I'm one of the co-founding partners here at Sterling Seacrest Partners. For those who don't know us well, we are a multidisciplinary commercial insurance agency with deep verticals in healthcare, construction, real estate and hospitality, transportation and logistics, nonprofits, and private client risks, which you would know otherwise as personal insurance. We also have a large benefits consulting practice to assist with the design and implementation of group benefit programs. If we can help in any of those areas, obviously we're in the business to generate relationships, and we'd love to talk to you if we're not already doing business with you. Several of my colleagues are in attendance around the room today. Hopefully, if you haven't met them previously, we'll have some time after we break up. We're based here in Atlanta. We operate out of 6 locations, and we've got almost 200 employees at this point. We've been very blessed. Those areas that I mentioned are all areas that, Atlanta and a lot of the Southeast is growing in, so we've benefited from that. We appreciate everybody taking the time and joining us, and look forward to seeing you at future events. We have these regularly, so if you're here today, you're probably on our list, and if you're not, make sure you reach out to either myself or Katie, and we'll get you added. Before we get started, I want to thank Katie. I'm not even going to try to say her last name. If you've seen it, it's Hawaiian. It's very difficult. We call her Katie K around here. But she does a great job putting all this together. She was here very early this morning, arranging for the breakfast, getting all the PowerPoints and all that stuff up. So I want to thank her for that, all the work that she does. I also want to thank our speaker, Phil Beck, for agreeing to be with us. He's prepared a great program today on construction contracts and related legal issues, and I'm sure will give us some great insights to take back to our companies and help us navigate through 2019. Phil's a partner here in Atlanta with the Atlanta office of Smith, Curry & Hancock. His practice focuses on construction law, government contracts, and commercial litigation. He joined Smith, Curry in 1981 upon graduating 4th class from UT College of Law and completing a judicial clerkship with the Tennessee Court of Appeals. He's experienced in a broad range of construction issues, problems, and disputes. Experience includes representing clients on a wide range of public and private construction projects throughout the country and internationally. He has drafted and reviewed thousands of contracts on behalf of owners, developers, GCs, subs, etc. Bill is also an experienced arbitrator and mediator of construction claims and disputes. If you're a member of AGC, you've probably seen him or read an article by him. He's very active on both the local chapter and the national board. He's also been the past chair of the Consensus Docs Content Advisory Council, so you're familiar with those documents. He had a hand in that whole, origin of those documents, so very familiar with all those and the AIA documents. Phil is also widely published in over a dozen books and numerous articles for various construction trade books. I'm very honored to have him here. He's a very good speaker, and by the looks of the turnout, you may have heard about him by reputation. So please join me in welcoming Phil Beck.
Can you hear me okay? Gosh, thanks, Doug. That was a very gracious invitation, or introduction, as well as an invitation to be with you here today. I've reached that stage in my career when you're a young attorney and people ask you how long you've been doing this, you try to exaggerate a little bit. But, well, you round up, you try to be truthful. But I've reached that stage in my life where I try to understate how long I've been doing this, because 37 years sounds like a really long time. And I'm gonna ask for a couple of show of hands today, but one thing I won't do is to ask how many of you were born after I started practicing law. Because I know there are some of you in here that would meet that criterion. I'm honored to be here today, and this is a great firm. I value my friendship with Doug and all the others here, John Shingler and other folks I've known for many, many years. It seems like every time I look at the Sunday AJC, somebody new is joining Sterling Seacrest. I used to have a law partner who'd been married 3 or 4 times, and and also changed law firms 6 or 8 times. And John used to say that if you live in Atlanta, there's a good chance that he used to practice law with you, used to be married to you, or you're his child. I feel like if you're in the insurance business in Atlanta, there's a good chance that you work for Sterling Seacrest, or you're going to work for Sterling Seacrest. So it's a great firm, and I know they do a great job for those of you in the room that are clients. I've got a number of clients that we share, folks that use me for their legal stuff and also use this firm. So I'm honored to be here today. I'm here for your benefit, and I hope that this morning, in addition to getting a free breakfast, that you'll leave with a few nuggets that you can use and apply. I know that I always learn something when I go to any kind of seminar or training session, whether I'm teaching or whether I'm in the group. And I think part of the reason, and I won't ask for a show of hands on this either, but I suspect all of you would raise your hand if I asked for any of you find that we have a dog attending today. How many of you, again, I'm not asking you to answer this, but how many of you find that your typical day, you don't really get to work on what you thought you were going to be working on that day? I was seated at a table at a mechanical contractor's function over the weekend, and you know, talking to people who are very successful in their field, and asked them, do you work on, when you go into the office in the morning, do you work on what you thought you would be working on that morning? And almost invariably the answer is no. I mean, you're dealing with emails, you're fighting the crisis du jour, and it's only when you take an hour or a day to go to some kind of educational program that you have time to step back and think sort of big picture for a few minutes, as opposed to fighting the alligators. So we're going to talk big picture a little bit today. I want to tailor this to what you have on your minds. I will stop by 9 o'clock and hang around if anybody has questions, but within reason, if there are a few questions as we go, you'll see I'm not speaking from a script, so don't worry about throwing me off. If you feel moved to ask a question or make a comment, or tell me I'm wrong about something, that what I'm telling you, because I'm not out there doing what y'all do for a living every day. I don't have what it takes to do what y'all do. I admire people that are in the construction business, and I will tell you, you have a gift I don't have. If I weren't a lawyer, I'm not sure what I would do. My baseball career peaked at about 10 years old, so I don't really have a plan B. I couldn't do what you do for a living. So if something I say today isn't what you've experienced in the real world, tell me. Because like I say, I'm always eager to learn too. The handouts that the people in the room have are just simply handouts of the PowerPoint show in case you want to follow along or make notes. And do the folks, Katie, do the folks on the phone have access to this information?
Yes.
Okay, good.
They can see everything that's going on.
Yeah, and anything I mentioned today, if you want something that I've got, you're welcome to it. Shoot me an email, and I'll get it to you. I'll probably touch on a couple of short articles that I've written recently that might be of some interest to some of you. I didn't want to load you down with paper today, but I'll be happy to share. And the clicker is right here. Where should I be? Okay. Something about that. What I'm going to primarily focus on is I've sort of grouped into three areas. You know, as a lawyer, you know, all my relatives were disappointed to learn when I got out of law school in 1981. I really didn't know anything. What you learn in law school is not the law so much. You do learn some basic principles, but you learn how to think like a lawyer. And part of thinking like a lawyer is putting things in cubby holes and recognizing issues and how to group things, how to compare them to something else. So we lawyers, like a lot of speakers, have a tendency to kind of group things in categories, and we love groups of three. So I've got three main topics that I want to talk about today. One is what I'll refer to as alternative project delivery methods, and I'll explain why I think that's important as we go. I'll talk about what I see as some of the contract issues that are out there, and then I'll talk about some of the recent changes to the standard industry contract forms that I suspect most or all of you are familiar with. The focus, I'd like to try to, if you've never, if you're new in the industry or if you're in the insurance business and construction's only part of what you do, and you're looking for sort of a primer on construction law and construction contract, I'd like to give you a little taste of that today, but I'd also like to hit what I see as sort of the cutting edge new developments for those of you veterans who've been in the industry a long time and just want to know what's changed in the last year. I'll give you some of that too. So we're going to kind of be traveling in time back and forth as we go through this today. I love this cartoon. I suspect many of you have seen it before. I used to be a big fan of Dilbert. I think they've kind of gone off the deep end now, but this was a Dilbert cartoon for those of you who don't recognize these characters. And Dilbert is making a business presentation, and he's saying, this project has a 70% chance of minor success and a 30% chance of corporate ruination. And his boss says, I like those odds. When can we start? And he's a little startled by that. To start, and his boss said, I wish we had 10 more projects like this one. Now, that's a cartoon because most people find that humorous. I don't get a laugh when I show that to contractors because that's your everyday world. I mean, seriously. I was sent one time to speak to a hostile audience who thought contractors were out to rob the public and make obscene amount of money, and I was there to represent the contractors, and some good friend of mine volunteered me for that mission. But I think if you ask, and gauging from the comments made then, and I think it's still true today, if you stop somebody on the street and say, what do you think the profit margin for a contractor? And they probably know 30, 40%, something like that, because they're used to hearing about retail, where you have, 50% markup, and they just perceive contractors are not, and after all, some of you do drive nice cars and have nice boats and nice second homes, and, they assume you're making an obscene amount of money. Now, unless I have been badly fooled over the last 37 years, the average general contractor or construction manager, if you're making 2 to 3% profit, you're doing pretty doggone well. Now that is 2 to 3% on a big number, and it's a number that includes work being done by your subcontractors, but still it's a pretty thin margin. If you're a specialty contractor, it might get up into the teens. If you do residential, it might be higher than that. But the point is, it's not a huge number. And the reality, and I don't want to depress you this morning, particularly those of you who are still eating, but if you think about it, one bad project can wipe out the profits from 10 years of good projects. And if you are a small to medium-sized contractor, you literally put your company's net worth on the line every time you take on a major project. And if it's a bonded job, you're probably putting your personal net worth on the line too, because you probably signed a general agreement of indemnity with the sureties of your personal assets are at stake too. Now, again, that's not to depress you. That's to say it's really important to keep your eye on the ball. You know, as a baseball player, if you're batting 300, if you get a hit 3 times out of 10, you're pretty doggone good. You got to do a little better than that as a contractor to stay in business. If only 3 out of 10 jobs are successful, then you got a problem. And so this is reality. This cartoon meant to be funny is not funny because that's the reality of construction. And that's why the point of that, at least from where I stand, is it's really important that you pay attention to the things that could erode that profit and erode that bottom line, because you can't afford to have too many really bad jobs. Here's where I will ask for a show of hands. I've done this many times over the years, haven't done it in a while. So let me ask it this morning. I'm going to ask you a purely hypothetical question. This is my lawyer disclaimer. No money is going to exchange hands through this exercise. We're not conducting illegal gambling here, and I'm not going to pay you to listen to me today. So this is a purely hypothetical question. I'm going to give you 2 choices, and I'm going to ask for a show of hands as to which of 2 choices you would choose. All right. First choice is I will hypothetically hand you a $100 bill. It's yours, no strings attached. You don't have to do anything to get it. $100. That's option 1. Option 2 is we'll flip a coin. And if you win the coin toss, you'll get $200. If you lose, you get nothing. Who would take the $100 sure thing? Okay, a number of you. How many of you would flip me for the 200? See, that's how I know I'm in a room full of contractors. Now, mathematically, and for those on the phone, I think, would you agree with me here in the room that by far the more people voted or will flip, we want the $200. Mathematically, those 2 options are exactly equal. 100% chance at $100 versus a 50% chance at $200 are exactly equal. So if we were all computers, we would say we don't care. They're the same thing. We'll take either one. We're indifferent. But we're not computers. We're human beings. And we're told by people that study us, study human beings, that most people are risk averse. Most people don't want to take risk if they can avoid it. They would take the $100. But in this room, that wasn't the outcome, was it? And I didn't expect it to be, because you've got contractors in this room. And contractors are not as risk averse as most people. We've just proven that again today. Now, I don't know what everybody who raised their hand does. I may be generalizing, but I will tell you, having asked that question many times over the years, contractors are not only going to take option 2, they're probably going to say, let's go double or nothing. Let's make this interesting. Now, it doesn't mean you're not a good contractor if you didn't take the 200 to flip option, but it just means as a whole, contractors are less risk averse than most people. And that's probably a good thing, or you wouldn't be in the business you're in. Most financial people, and I have I said I don't know what I would do if I wasn't a lawyer, and I meant that. My undergraduate degree was in business. I got an MBA in finance, along at the same time I got my law degree. Now, it was from the University of Tennessee, so that would cost some of you to discount that. But, if you take any sort of financial management course or economics course or anything else, you learn things about, there's supposed to be this logical trade-off between risk and return. And, to get people to take more risk, you have to offer more return. I'm here to tell you that in my years of experience, contractors are more willing to take risks than most people. And I don't know if owners know that, or they know it intuitively, or they have just, or they do it without thinking. But part of the reason that contracts tend to be so one-sided, in my experience, is because contractors are willing to sign it. Contractors are willing to take risks that maybe some other folks would not. Now, I said I would talk about project delivery systems, including why I think that's an important topic. And today, there are more items on the menu than ever before. This is the main takeaway I want you to remember, because I will tell you there are many lawyers that don't understand it. And this is this, that the project delivery system that you're operating under, the contract structure, dictates the contractual relationships between the parties, the roles and responsibilities of the parties, and the risks and the paradigm. I'll explain what I mean by that. When I became a construction lawyer in 1981, most construction in this country was done under the traditional general contractor model, where the owner would hire a design professional, except at that time we didn't call them design professional, they were just an architect or an engineer. But they would hire someone to design their project. It would be, in theory, 100% complete design. They would then put that out for hard bids, and the various general contractors would compete for that based on price only. It's an apples-to-apples comparison. You're only looking for the lowest price. And they would, of course, subcontract some of the work. Back in those days, most general contractors did self-perform at least a portion of the work, but they subbed out some of the work as well. And that's how projects got built. And it's the important thing, and I'll say that in most states back in the early 80s, that was how you had to do it by law. That the law required for public work. You had to have hard bid, competitive sealed bid, competition for contracts. And even in the private arena, that was sort of the norm. Now, a lot of the well-established legal principles that you hear about as a lawyer, and I suspect some of you hear about as non-lawyers, came out of cases where that was the contract structure or that was the project delivery system that was used. And that's a very, very important thing to keep in mind, because things that you think you know may not be true when you go to a different paradigm, when you go to a different contract structure. And I'll explain what I mean. One of the legal principles you learn early in your career as a construction lawyer is the Spearing doctrine. I mean, you've at least heard the term Spearing doctrine. And if you're a construction lawyer, the way you impress people at cocktail parties, talk about the Spearing doctrine. Well, the Spearing doctrine comes out, it takes its name from a 1918 U.S. Supreme Court case, and basically just stands for the proposition that under this delivery system, when the owner hires this design professional to design the project and then hands that to the general contractor and says, build it, even though the owner may not realize it, and even though there's probably nothing in the contract that says this, the owner has impliedly, because nothing says it, it's impliedly warranted to the general contractor that if you use this, it'll work. And if it doesn't work, if it's a bad design, then the contractor has some recourse against the owner. The owner didn't design it. The architect did, but the contractor doesn't have a contract with the architect. So they have a right to sue the owner who gave them that design and made that implied warranty, even though they may not realize it. So that's the Spearing doctrine. Well, keep that thought, as one of my partners likes to say, and we'll come back to that in a minute. But that's a lot of the well-established case law comes out of this delivery system. And so lawyers, I've seen many a lawyer who calls himself or herself a construction lawyer that doesn't really, but they don't really appreciate that when the circumstances and the contract structure changes, rules change. How many of you heard of differing site condition claims? That's another common type of claim, and that's the idea that if when the contractor gets out there to build this, they run into some condition, usually below the ground or in a wall if it's a renovation project, some concealed condition that they didn't have any way of knowing about. It's either different from what's shown in the contract, or it's different than what you would normally expect to encounter in doing work in that area. And it costs you more money. You have a basis to recover additional compensation. Well, that's a great legal theory, but it only applies if the contract says that you have that right. And the standard federal government construction contract has what's called a differing site condition. All the standard industry forms have a differing site condition. So they're a little bit different, but they create that right. Well, what happens if the contract doesn't give you that right? Now the rules have changed. That's why I defended a case in Asheville, North Carolina, a number of years ago, and the lawyer on the other side, who called himself a construction lawyer, made a really great, in his complaint and in arguing his case, he really understood different site condition clauses and made a great argument, except he lost track of one thing: the contract didn't have a different site condition. So his argument really wasn't worth anything. So keep in mind that as the rules change, the results change. I'll come back to that slide in a minute too. Let me ask you this: who's heard of and or does CM at risk? Construction management at risk has become very popular in recent years, maybe become the most popular of the project delivery systems. But if you were to draw on an organizational chart format, as I have done here, what CM at risk looks like, it's really pretty much the same thing as the old traditional GC. In fact, if you look at the heading I put on this slide, I'm going to get back to it. I've labeled this slide General Contractors and CM at Risk because that's what CM at Risk looks like too. The only difference is we're now calling this General Contractor. And perhaps instead of being a fixed price contract, this is now a cost reimbursable contract, perhaps with a guaranteed maximum price. And probably this construction manager is getting involved in the process during the design phase instead of waiting until the design is complete. So the timing changes, the names change, but the payment vehicle changes. But the structure looks pretty much the same. Contrast that with CM at risk. CM agency or pure CM, and that's a little different deal. at least as I think of, and you can have all kinds of different variations of these, but at least as I think of pure CM or CM agency, the construction manager doesn't, quote unquote, hold the contract with the trade contract. Probably isn't at risk for the cost of the project, probably isn't at risk for the schedule. So what would that look like organizationally? Well, they're essentially an extension of the owner. They are essentially a consultant to the owner. If they don't hold the contracts, they don't have budget risk, they don't have schedule risk. And that, of course, changes the dynamics as well. The CM at risk, CM agency, design build. How many of you do design build or have clients design? Become very popular. There was prediction probably 15, 20 years ago that within 10 years that would make up the majority of construction in the U.S. I don't know that that's proven to be true. Like a lot of predictions, it probably is taking a little longer than we thought it might. But it certainly has become more and more popular. It's basically the owner looking to a single entity to both design and construct projects. Now, as many of you, most of you probably know, that entity could be a company like a Floor or a Jacobs or a lot of smaller companies too that does both design and construction under one roof. It could be a joint venture, which is a fancy word for a partnership for a limited purpose. It could be a design firm and a construction firm that come together to do this project together as a design build team. I was involved in what I believe to have been the very first design build job that Disney ever did. It was an infrastructure project in Orlando, and their early notion of how to do design build was it was a shotgun marriage. They picked their designer, they picked their contractor, said, you guys are going to work together and deliver this project. And infrastructure is probably a good example of something that for an owner like Disney would be a good way to use design build, where design build might not work so well for a lot of their other construction. Because in design build, the owner is giving up control. Some owners, I've had many owner clients tell me over the years, I don't want design because you got the fox guarding the hen house. I want the contractor and the designer to be a little adversarial. I want a checks and balance system like our U.S. government. See what else got this with. But I want the architect to tell me if the contractor is doing something wrong. I want the contractor to tell me if there's a design problem. I don't want the two of them in cahoots together. If you're an owner that wants to be very hands-on in the design, like a Disney, or like a lot of the casino companies I've worked for over the years, design build may not be your best solution unless it's for something very functional like a parking garage or an infrastructure project, because you want to be more involved in the design than delegating it. But here's where I said I would come back to another point. What happens to the Spearman doctrine in the design build scenario? Ain't no such thing. Because the owner didn't hire and provide the design. The owner hired this entity to do it. So if this entity's design is different than what they encounter in doing construction, that's their problem. So steering goes out the window when you go to design build, unless perhaps it's a type of plane that somehow the designer has relied on information furnished by the owner. What happens to different site conditions? Something else I referred to earlier, if you're doing design. Well, certainly more limited. You're not going to be able to make a different site condition claim because you encountered something different than the design anticipated, because you're responsible. If there's some site condition, then perhaps you could. Just to finish my thought, this design, I earlier thought about who this is. The design builder could also be a contractor who then hires a design professional to do the design. So that architect you complained about all those years is now your subcontractor. And you think that's a good thing, but now he has to answer to me, but it also means now you're responsible for him too. So it's good and bad. Like everything else in life, there's trade-offs. Or, at least in some states, this could be an architect that hires a contractor. Some states can't do that. North Carolina, for example, whoever holds the contract with the owner to build the project has to be a licensed general contractor. So unless that architect also has a general contractor's license, unless the law has changed very, very recently, you can't do an architect-led design build team in North Carolina, but most states can. Okay. So it matters. IPD, who's heard of Integrated Project Delivery, or IPD? I began my construction career. It's funny, the way being a construction lawyer was explained to me when I first became one was what we do is we talk on the phone, we travel on planes, and we fight with people. And that's kind of what we did. Being a construction lawyer usually meant that you represent the contractor or subcontractor. Back in those days, most owners didn't hire folks who specialized in construction. They already had their army of lawyers, and they used them even though they knew nothing about construction. So you represent contractors, and it was primarily claims, arbitration, litigation. I'm glad to say that that has evolved some over the years, so that before the Great Recession, 15, 12 years or so ago, my practice had evolved to the point that I was spending at least half of my time writing and reviewing and negotiating contracts. And sometimes my client was that owner who now realizes it wouldn't be a bad idea to get somebody that actually understands construction to help us with our construction and design contracts. But, I heard many owner clients tell me over the years that one of their biggest beefs was why are we the one getting sued all the time? We didn't design the project. We didn't design the project. We hired the architect to design the project. We didn't build the project. We hired the contractor to do that. Our only job was to provide them a site and the payment table, tell them generally what we wanted. But yet we're the one getting sued for millions of dollars when something goes wrong. What did we do wrong, and why are we getting sued? And of course the answer was always, look at the lines. You're the only one that has a contract with either of those stuff. That's why you're caught in the middle contractually. And that's why you're the one getting sued. And it occurred to me a couple of decades ago that, wouldn't it be kind of neat if you could come up with a contract where where that wasn't the case? Why couldn't the owner and the contractor and the design professional all be parties to the same contract? Why can't you have a three-party contract? And that way, if the contractor has a problem with the design, they can take it up with their they're contracting their other contracting parties a designer rather than making a claim against the owner who did nothing wrong. You know, and I never did anything about it other than muse about how interesting that would be if I had some free time to see if I could develop that. That's what IPD is. Somebody beat me to the punch. I guess I should have watched less football and played less golf and developed the IPD contract and copyrighted it. But that's what through IPD, Integrated Project Delivery, is a three-party contract. It is a single contract from three different parties, puts you all in contractual privity, as we lawyers would say. So you're all accountable to each other, and you all have your respective roles to play. There are forms for that. The Consensus Docs 300 is an IPD contract form. AIA now has a version of an IPD form. One of the leaders in getting into this was Sutter Healthcare out on the West Coast that sort of pioneered this. There was a law firm that did a lot of work for them out there. But it's called Traction. There are folks that do this. There's a large furniture company, office furniture company here in Atlanta that does IPD projects. So you see it some, not a whole lot in its purest form, but you see it some, and I expect you'll see it more. It's new, it's different. In the public arena, there may be legal limitations on your ability to do this, but it's gaining some traction. What I see more of, and I suspect y'all see more of, is what I would call IPD-ish or IPD-light, where you don't have a true three-party contract, but you try to practice some IPD principles. Try to get the design, the CM or contractor involved earlier in the design process. You try to have the three working together to develop the project, and each have their own areas of responsibility, some shared responsibility making of it based on what party's role is. So you're seeing a lot of what's called IPD isn't what I would call pure or true IPD. It's IPD-ish or IPD-light. But I suspect so if you heard the term, but this ain't what they're talking about, there's a reason for that. People see the value in a collaborative process. Even Disney, somebody I invoke, they're doing what they call IPD. It's not a three-party contract, but it is invoking IPD principles of collaboration and lean and BIM and all those cutting-edge terms, and I'll talk about a little bit more in a minute. So that's IPD. Obviously, that changes the game in terms of contractual responsibility. And I would say there is no spirit doctrine for IPD. You look to the designer himself or herself as opposed to looking to the owner. All right. I represent, I don't mean this to sound like promotion, but I guess there's more to tell you my biases and my experience. Having cut my teeth as a lawyer that represent almost exclusively general contractors. In fact, many people still think of our firm as a general contractor firm. I now represent as many subcontractors and specialty contractors as I do GCs. And I represent owners, not nearly as many owners, but if you look at how I spend my time, I spend at least half my time representing owners because the owner work, for whatever reason, tends to be larger assignments. A lot of it is contract stuff, but a longer engagement, if you will. Yes.
Phil, some of these contractual structures aren't they? Can you speak a little bit to how they affect how change orders are perceived by the owner or how they're addressed?
Great question.
Aren't a lot of them
Great.
structures developed to avoid change orders?
That's a great question. And I'm glad you asked that. Change orders. I assume everybody heard that even on the phone. Some folks tout design build as being attractive to owners because you eliminate change orders. In fact, I think at least at one time, and perhaps still, the Design Build Institute of America sort of promoted design build as a way to get away from change orders. And change orders are almost a dirty word for owners. Some owners don't believe in them, don't give them out. You've all probably seen the cartoon or the picture of the little dinghy that says contract on it and the yacht tied next to it that says change order. I think a lot of owners perceive, and just telling you, just the messenger here, a lot of owners perceive that contractors deliberately underbid the job to get their foot in the door, and then they make their money on change orders. Now, again, unless I've had the wool pulled over my eyes for my entire career, that's not a very good business model. That don't work, because change orders cost the contractor more than you can ever recoup for it. But to get back to your question, yes, people promote design build as a way of avoiding change orders. I would say it certainly does minimize and eliminate certain types of change orders. And if the owner will stand back and let the design builder do their thing, it may practically eliminate change orders. But if the owner is going to muddle and say, well, this isn't what I thought it was going to look like, I want something a little different, or they're going to dictate the design, you're still going to have change orders. So no delivery system will guarantee you won't have change. I like to say that the change order and claim are really not four-letter words. I mean, if you're eating dinner in a restaurant, you order the chicken dinner, and the restaurant goes and the server goes by with a steak, and you say, "Gosh, that looks real good. I think I like one of those instead." And then you get a bill that's for more than the chicken cost. Are you going to complain about it? No, because you changed your mind about what you wanted. But yet, I mean, that's to me an appropriate analogy. So there is some validity to that. It's like a lot of things in life, particularly in politics. There's enough truth in that it gives people something to talk about, but it's not absolutely true. It depends on. Now, if the owner says, just give me a building that will satisfy these criteria, and I don't care what it looks like, I don't care how you get there. I'm all about function, not style. Then it is conceivable you could totally eliminate change orders, because if something ends up not working quite the way the designer thought it would, that's their problem. So there is a correlation, but it's not a perfect. A good question. All right. When I represent, and I'm just saying this at the risk of offending some of the general contractors I know are in the room and me and my clients, when I'm asked to review a subcontract on behalf of a subcontractor, frankly, I think that's some of the best bang for your buck you can get from a lawyer is instead of waiting to have the autopsy performed after the project is in the ditch. Spend a little bit of money, and I'm talking a couple of hours or two of work on the front end, at least having your lawyer and your insurance agent and your bonding company, if it's bonding, look at the contract, at least tell you what they see as the problem. It doesn't hurt to have another set of eyes. It doesn't hurt to get the lawyer and the insurance perspective on the contract, and I think you can avoid a lot of problems. You may decide you don't want to do a project. I've had a client do that recently. it's funny that we fought tooth and nail to negotiate a contract, subcontract we could live with on a project up in Nashville. And we thought, okay, that was pretty expensive, but we came up with a good, fair contract, and now we can use that going forward. Well, the general contractor turns right around and wants to use my guy on another project here in Atlanta, but doesn't want to use the contract they negotiated in Nashville. He wants to start back at square one. My guy just said, forget it. There's enough work out there. We don't need it. So anyway, but it, within limits, within budget, it's a good use of your lawyer and your insurance agent. And I will tell you, what I do in that process, it ain't rocket science. If you are a construction lawyer and you've seen what can go wrong on a project, and where the problems are likely to arise. I am a big advocate, and if you want to call this self-promotion, you're welcome to. I don't think you're qualified to write a construction contract unless you've litigated some construction projects and you know what can go wrong and what's important, what the traps and pitfalls are. And I can tell the minute I look at a contract whether the person that wrote it really knows anything about construction and construction disputes. But getting the benefit of having somebody that has been through the wars look at it and tell you where the bad things are, and maybe ways you can make them more palatable that the other side would have a hard time arguing with, is money well spent, in my humble opinion. But again, it ain't rocket science. It usually boils down to about 10 or 15 things I see over and over and over. Every once in a while, I'll see something in a contract I've never seen before, and I'll go, whoa, that's out of left field. That's a new one. But usually it's the same thing. So here, for the price of admission today, I'm going to give you sort of my checklist of things to be most concerned about. I'll be mindful of our time. But the first one is identity of the parties. Now that sounds kind of basic, but in my mind, and taking nothing away from what I do or your insurance person does, the most important thing in any contract, in my view, in my experience, is whose names are in the blanks. Who are you dealing with? And I mean that in at least two different ways. Number one, who is the entity you're contracting with in a very strict legal sense? Because people lose sight of things sometimes. Wait a minute, this name you've got in a contract is not the name that's on your letter. Who is this entity? And I'll give you an example. I'll give you a very graphic example. When I talked about the fact that 15 years or so ago, a big chunk of my work was owner work, writing contracts. I had a couple of casino clients out in Las Vegas that I did a lot of work for. I spent a lot of time out there on business. Not a big gambler, but I did enjoy going to Vegas. And for those clients, it wasn't litigation and it wasn't claims. I was helping them negotiate their construction contracts and their design and consulting contracts. And I'd like to think most contractors I dealt with appreciated the fact that, we at least were arguing about things worth arguing about and focusing on the important things. And usually it was a good relationship, and even I got a plaque at the end of the project celebrating the success of the project from the contractor. But anyway, in the company that I spent most of my time working for was a company that many of you have probably never heard of. In fact, enough time has passed, I'll tell you their name. It's Station Casinos. Now, Station Casinos, they're not the Mirage or the Venetian, who we also did work for. The Station Casinos' market niche was they didn't want you and me. They didn't want the gambler that went out there once a year.
They wanted the local market that would gamble 50 times. And so the way they structured their business, the hotels weren't Bellagio quality. They were more like Holiday Inn quality. They were fine. But, you know, they weren't on the Strip. They didn't own a single property on the Strip. But they had the Strip surrounded. They had properties all around the Strip. They did ultimately build a couple of pretty high-end properties, one called Green Valley Ranch out toward the airport that I did all the contracts for, and one called Red Rock, which is another really nice property that's on out near Summerlin. But they were going for the local market, a little higher payout than the big names, free parking, food, anyway, that was their market. They were a very successful company. They were, at the time, very profitable. They were ranked as one of the most successful companies in the country. They were ranked several years as one of the best places to work in the U.S. A little interesting tidbit. Here's your other takeaway for today. The two principals were two brothers named Frank and Lorenzo Fertitta. Frank Fertitta was the founder of this UFC deal. I actually did a little bit of work on that too, but the guy had a Midas touch. He's one of these guys you hear about and they know that could walk in a casino, say, change that, change that, change that, and in 5 minutes tell you what it wasn't going to work. But Frank guy, I represent him on his home. Don't ever build a house for him, because you'll never satisfy him. You know, he took me in to show me all the problems with his house, and I said, Frank, it looks pretty good to me. But anyway, the point I want to make, though, there is a point to this story, is that when you built a project for them, your contract wasn't with the company I just described. Your contract was with a single asset, limited liability company that owned that one property where you were working. And even casinos do sometimes run out of money and get in financial trouble, as happened in New Orleans with some casinos. Harris, who we also did some work for, had a casino in New Orleans that actually filed bankruptcy. But so your contract is not with the I just described. It was very profitable, great place to work. It's with a single asset entity, and you didn't have any recourse against Station Casinos if that single asset entity didn't have the ability to pay you. That happened. Now that's an extreme example, maybe. But how many of you do condo work? You know, if you may be working for one of the largest condo developers in the world, but your contract is not going to be with that entity. It's going to be with a single asset entity, meaning they only own one asset, that project, that owns that property. And with condos, it's particularly concerning because what happens when the project is complete and all the condos are sold? That entity no longer has any assets. They don't exist anymore. They disperse the profits, they're gone. So that when the condo commandos come in 8 years later, right before the statute of repose runs, and files a suit against the contractor and the developer because of alleged deficiencies in the construction, well, that owner's no longer around. They don't exist anymore. So be real careful about who you're contracting with in a very strict legal sense. Also be careful about who you're dealing with about, have they done this before? Are they doing something they've never done before? Do they have the people in place that, you know, it sounds sort of counterintuitive. As a construction lawyer in litigation, I like to have an opposing lawyer that knows what they're doing. Because you can waste a lot of time and money fighting about things you don't need to be fighting about if the other side doesn't know what they're doing. I, as a contractor, don't want to be working for an owner that doesn't know what they're doing. Because it will invariably cost money. Unless they just trust you blindly, it's going to cost you money. So, what's their reputation? How about the individuals involved? Are they people you can trust? Some owners have a reputation of having the guy that you have all these handshake agreements with during the job, and you get to the end of the job and he or she gets pulled off the project and somebody else comes in to close it out, and they don't even have to pretend they don't know about all these agreements you have. They don't know about it. So who are you dealing with? I think is the most important thing to know. Dispute resolution, maybe it's because I'm a lawyer in part, but how does the contract say you're going to resolve disputes? You hope you're not going to have any, but you may. And if you do, how are you going to resolve them? I did some work years ago for a mechanical contractor up in Akron, Ohio. Only did work in Akron. They were based there, guys. In fact, I ran into somebody over the weekend at Ewing, the principal of the company. And they only did work in Akron. They were going to work for an owner they had never worked for before. An owner that they did a lot of work for before, but the construction manager that the owner hired, they had never worked for. And in their subcontract, it said if you have a problem with us or a claim or feel like we haven't paid you, you've got to come to Atlanta, Georgia to fight about it, and then we'll decide whether we want to arbitrate or litigate. So that's how I got hired by that particular client. And we got a good result, but it was a bit of an inconvenience and extra cost to have to bring all of our witnesses. And if you do church work, if you do work for the Mormon church, the Church of Latter-day Saints, unless it's changed recently, unlike the Methodist church I grew up in or the Presbyterian church, when you do work for the Mormon church, you're working for the new Mormon church in Salt Lake City, Utah. And unless it's changed since last time I looked at their contract, it says that if you have any issues with us, you've got to come to Salt Lake City. And we'll fight about it there, even though the project may be in North Georgia. So arbitration versus litigation versus mediation, whenever you're going to do those, I think those are all important things to think about. Time of completion. In my experience, most big dollar construction disputes are a function of time. If you have scope changes, if the size of the project changes, those tend to get resolved. The ones that don't get resolved is where the project's 6 months over schedule, costs the owner money or lost revenues, it costs the contractor money, costs everybody money, and nobody got any benefit from that money. So those are the ones you find about. So what does the contract say about the owners or general contractor, if it's a subcontractor, their right to dictate your schedule, change your schedule, accelerate your work? You get paid for overtime. Is the time allowed reasonable? Does it have a no damages for delay clause that says even if we delay you, you don't get any money for that? So anything relating to time or schedule changes. In the interest of time, I won't ask for a show of hands on this, but I'd like to ask how many people have been involved in projects where nothing changed. Very seldom do I have anybody say that they've ever seen the project. I mean, change, even in the time build, change happens. And you don't know what's going to change or why it's going to change or when it's going to change, but you know something's going to change. So therefore, I would suggest that it's really important to see what the contract says about that, because not all contracts are the same about whether you get paid for that, when you get paid for that. If it's a change that delays the project by 6 months, do you get paid that 6 months of additional job site overhead, or are you limited so that the only overhead you get is a set percentage of your direct costs? Well, that may be great if the change order adds a lot of direct costs. What if it adds no direct costs, but it extends the project? So what does the contract say about changing? Site conditions, we've already touched on. Payment, how many of you like to get paid for your jobs? Generally, I don't think there's anything immoral or unethical about wanting to get paid. I kind of like to get paid. I wish I was independently wealthy, but I'm not. So what does the contract say about your right to payment? You have the right to stop work if you're not paid. If you're a subcontractor, and here's a dirty word for subcontractors, doesn't have a pay when paid or pay if paid clause that says you only get paid if the owner pays the GC. I can argue either side of that argument, who I'm representing. If I'm the sub, my argument is I'm looking to the general contractor and manage that relationship. What happens if the reason you don't get paid is because you or another sub did something wrong that has nothing to do with me? Why should I be penalized? If I'm the general contractor, my argument is, well, I'm a contractor. I'm not a banker. You understand that the way I'm going to pay you is the owner is going to give me the money, and then I'm going to give it to you. If the owner doesn't give me the money, I don't have any money to give to you. So, it's debatable, and I've come up with some compromise language on that for this client. Notice. Notice serves a legitimate purpose. If I'm an owner or a general contractor and something happens on the project that may impact cost or the time, I want to know about it. I don't want to run the risk of just having you casually mention it to somebody on the job. So it's important enough to already send me a letter or maybe an email, something in writing that will get my attention so we can address it. Maybe there's something I can do to reduce the impact of it. But I'm also not naive. You see a lot of contracts that have notice provisions that are unreasonable and, at least in certain circumstances, impossible to comply with. And those are, quite frankly, often intended to be barriers to claims. So the notice provision that says you have to give notice, written notice, within 48 hours of the time something happens. Not the time you discover it happened, but the time it happened. Well, what if something happens right on a Friday evening after everybody's left for the weekend and you don't discover it till Monday morning? Well, 48 hours are done. So what do you do about that? So, I look at that. Indemnification and insurance. I'm not going to just talk about that because of where I'm standing, but those two topics, which are different but related, have become a real battleground in the last 10 years or so. It's funny, the way I would suggest you think about insurance, a lot of people use the terms risk management and insurance as synonymous. In my mind, insurance is just one tool for managing your risk. There are risks you cannot insure, but you ought to look at insurance as a means of reducing your risk. Interestingly, what I've seen in contracts in the last 10 years is parties getting more aggressive and burying in the insurance provisions things that try to put more risk on you. And in the indemnification provision, very much the same. So, most lawyers' eyes glaze over when they start reading indemnification and insurance provisions. They are extremely important.
We have a common question under the design build delivery mechanism. So now the general contractors either got their own architects or they're subbing it out. Now I've got responsibility for design when you did the old method, that was totally separate, and it was the owner's problem how much limit the architect carried, which was typically not enough. Well, now it's under the GC umbrella, and the common question we get is how much coverage should I require, and then that's kind of a challenging issue. But beyond that what would be the contractual remedy you would recommend? I mean, should we try and limit the the liability for the design to the amount of the limits carried. I mean, you know, it's kind of, you know, in the past, when the architect carried it themselves, he was carrying $1 million limit, and it was woefully inadequate, but it was not our problem, per se.
Right.
It was the owner's problem. Now it's our problem.
Great question. I'm not sure I can do it justice in the time we have, but it is a great question. The fact that you're even having that dialogue is a good sign, because I think a lot of, particularly subcontractors that are doing design build, don't appreciate that they're now taking on additional risk that their GL policy is not going to cover, that they, unless they put some sort of professional liability coverage in place or require their designer to carry it, that they're exposed. Most design firms don't have a lot in the way of assets, so the insurance policy is all you've got to look to. And most professional liability policies are claims-made policies, so that if somebody else, you could require them to carry $5 million of coverage, but if somebody else beats you to that $5 million of coverage, then they may be in effect applying naked. So I think how much is enough is obviously depends on the project, but it's funny, for years, and I still see big architectural firms carry $1 or $2 million of professional liability. I've dealt with some of the biggest architectural firms in the world, and I only carry $5 million. I think if you're doing building construction, that's sort of, I think, still the norm. You get in the industrial world, and you'll see $20 million policies. I don't know how much, and I don't know that any amount is enough if somebody else beats you to that coverage. I mean, that alone, I've got a client who's a electrical sub who's like a eye-opening thing for him here recently to realize he had that exposure. He didn't realize he had, and he's part of a peer group and has asked me to come speak to their peer group in a few weeks about that subject, about the sort of the hidden risk of design and build for a contractor. But you definitely ought to be obtaining insurance, either yourself, there are protective policies available that you as a contractor can obtain. You can also require your downstream party to do it. I've written language in the contract that requires them to give you notice of other claims made against their policy. Mm-hmm. So you're at least aware that somebody else out there might beat you to that coverage. I did when the State Bar of Georgia bought the old Federal Reserve building and turned it into State Bar headquarters. I actually represented the bar, and I'm not sure they liked it, but we put that in the architect's contract. It had to carry a certain amount of coverage, and they had to notify us if there were any other claims made against policy. But you don't typically see those. But it's a really hot issue. Indemnification provisions that say that you must indemnify the other party, the owner or the GC, for anything that happens in connection with your work. Guess what? You're now their insurance company, because you're taking on responsibility for things that you didn't cause. And in Georgia, those are unenforceable if they attempt to make you responsible for something that is 100% their fault. But how many times in construction is anything 100% anything? If it's 99% their fault and 1% your fault, but you've agreed to indemnify them because it arises out of or relates to your work, you're on the hook for the full amount. So, they're very unfair, and I'll tell you again, and I'm not just saying this because of where I am, I pay very close attention to insurance and indemnification provisions. And no matter how much I think I know what the problems are, I always say, and talk to your insurance agent about this too. Do you have the coverage they say you have to carry? If you don't have the coverage, what's it going to cost you? I'm seeing indemnification provisions that now require that you have insurance that is as broad as the indemnification provision. But if the indemnification provision covers intentional acts, I'm not sure you need insurance for that. Yes. If you don't want, since we did that contract, I think we did. I think we gave ourselves the right to withhold money to protect ourselves. The other thing that happens is, you could have claims arise, particularly design claims, after the project is paid out. So one other thing we do is require them to continue to update their insurance information after the project is complete. You don't have as much protection at that point, obviously, but at least you do what you can. We talked about design responsibility. The final thing I'll say, and I'm coming up on the end of my time, I'll probably there. Termination. You never go into a project that expecting that the relationship is going to end before the project ends, but it sometimes happens. So, a lot of contracts have both a termination for default clause that entitles the upstream party to terminate the downstream party if they don't perform properly. But a lot also have termination for convenience clauses that give them the right to terminate even if you haven't done anything wrong. Pay close attention to those. The AIA forms change significantly with regard to their termination for convenience clause. I said I would talk about in this last round in 2017. Let me just give you 2 minutes on the forms that I said I would touch on. I talked about Andy's site. AIA, the A201, which is the most important in their family of contract documents for contractors, the general conditions. They're on a 10-year renewal cycle, so those were just renewed in 2017 or updated, refreshed. There were there are a number of forms if you're still operating under the 2007 AIA forms. I know people that are still operating under the 70s because they like them. But if you're still working under 2007, they've been retired, and which means that as of about 3 months ago, AIA software will not support them. Some people still have their own bootleg copies of them that they've turned into a Word document that they're using them. But AIA that no longer supports use of the 07 earlier forms. Some of the major changes, they took away my biggest pet peeve. There was a provision in the AIA contract which said the owner and the contractor were not to talk to each other. They were to communicate through the architect, which to me was the most asinine thing I ever saw. The two parties to the contract can't talk to each other. Of course, that's why you're going to have disputes. They did do away with that, unfortunately. I don't get to complain about it anymore. They changed insurance to an exhibit now to make it a little bit more flexible, but I think in part that's a reflection of people using that as a battleground. But pay close attention to that. This is the thing I mentioned to the C4C's provision, which used to be very contractor friendly, and no longer is. In the slides, I've hit on some of the major changes. But if you're interested in trying to look at those, best thing you may want to do is go to their website where they actually make it really easy to look at what those changes are, and I've given you that information in the PowerPoint slide. Consensus docs, Doug told you in introduction, I've been heavily involved, so I am biased. But consensus docs, which have already been around for about 11 and a half years now, is an alternative to AIA. It started out as a group of 20 industry associations, including both of the major general contractor organizations and a lot of specialty contractors, some insurance and surety folks, etc. But it has grown in those 11 and a half years to 40 organizations, including the AIA, not that AIA, they were asked to participate, they declined, but the American Insurance Association is a participant in that. I really commend them. There's a logical order to the way they're structured. I mentioned the 300 document, which is where you would find the IPD. There's also what's called a DIM addendum that is in the 300 series if you're dealing with them. I think I really would commend them to you, even if you're not in a position to dictate whether they're used on your project. It's a good resource to look at for alternative ways of handling certain issues. I think they are more fair and balanced, represent the interest of all the ones, of all the facets of the industry. There were some changes to it too in the past year or so. Again, you can get that information off of their website. But I would commend them to you. Take a look at it. I think they are a valuable tool and they are gaining traction. And AIA's been around for over 100 years. Consensus Docs has been around 11 and a half, and I think they are, it's clear AIA doesn't like competition. But I work with both. You can work with the AIA contract forms, and we'll be happy to talk more about that. But not today, because today we're at the end of the time, and I will hang around and answer any questions or visit with anyone that would like. Otherwise, that's all I have. Doug, any
I would like to add just two thoughts, or echo a couple of things. One, on the indemnity provisions that you mentioned were so important. Those are really important to look at on a state-by-state basis because the indemnity statutes vary significantly from state to state. And I think that's one of those, we talked about preventive medicine. When you're going into a new location, that's not something you want to miss. You don't, your insurance provisions might not be in compliance with what the indemnity provisions are in that state or in that contract. So we would strongly recommend, you take them up on that preventive medicine kind of thought if you're not already doing that. We see staying out of trouble is much cheaper all the time than getting into it and fighting about it. The second thing I wanted to add is, we talked a little bit about change orders. If you're working for a state entity in Georgia, I would encourage you to look at a case that's being litigated through, I think it's at the Supreme Court. We're waiting on a ruling. Many state entities in Georgia, stand behind sovereign immunity defenses. I've got a client who, in good faith, did a bunch of change order work for a county entity in Georgia, and basically they refused to process any of the change orders, and then on top of that said he was late and didn't give him his retainage. And they went to court, won a total smackdown at the trial court level, and the state appealed it on sovereign immunity. Half the claims were thrown out. I'm really worried about that. I've talked to the ATC folks about it. I mean, if you can't trust the counterparty, a sovereign immunity defense is really something that, if you're working for state entities, you better be clear about what the change orders say, because if you proceed with work without proper documentation on change orders, proceed at your own risk. You might be bearing a lot more risk than you understand, because that's a big deal if that comes out adversely to the construction community, which I think it may. Lastly, we got, if you put some business cards in, we got some Tech basketball tickets to give away.
Curtis Henry with Flying Form Structure.
All right. Well, thanks for coming out. We're sorry we ran a little bit over. Watch out for our next invitation. We've got another program on the 19th on cyber awareness, which is a big-time topic that you're reading about in the paper every day, if not hearing about claims related to that, which we are. So watch out for that. Thanks so much. Hey.
Thank you all. I think I know you're going to come back. I do know about it. Yeah. I didn't really have it.
I don't understand what the narrative is moving forward from that.
And I will tell you, I know very well what they did when we were our job. David was this Kansas, David was a little bit on the fence. David was a little bit on the fence about whether he wanted to call them all the weapons to try to attack him, or whether he thought he could maybe get an overturn, get the result much narrower ground, and that might be easier than trying to kill him. It's scared, and their state's worse than Georgia, California. They got really straight. Well, thank you very much. He said he was thinking about coming to the I'm really delighted. He speaks very highly. Playing him again. I believe I assume he's playing him. Today's a real good job. Thank you. I know something. We'll tell Dave for Jordan. I know.
You got water.
I got water, I'm good.
Rest of them down there on the left. You got that.
Your experience now, and it'll be.
Well, the reason
I wouldn't want to have them on my